So the next session is to try and set up the framework for the legal part of the workshop, and show to the participants what are the legal issues when contributing data. And again, the purpose is to make sure that people feel comfortable with the legal aspects, and they should also feel that in some cases, when we are talking about the public sector initiative or public sector data, there is a number of regulations that would make their life more easy if they want to donate the data. And this is an oral presentation, 30 minutes, and as I suggested earlier, it could be 20 minutes presentation and 10 minutes question answering. It would be nice that the speaker is someone with strong local background, but not necessarily a lawyer. Lawyers have this tendency to go into tiny details because that's how we pay them very high fees. So if someone is familiar with our community because he's working in an institution that deals with data, licensing, copyright management, and things like that, it would be nice. What we have seen in many countries is that the Creative Commons movement, they have this European network, and they are very familiar with both Creative Commons spirit, which is licensing under very permissive conditions, but also resources or data that looks like language resources. And I think we said this morning that one of the tasks of the project is to establish a help desk where people can get support on the legal aspects, and this is already in place. So the session is about this legal framework with a very strong focus on the public sector initiative, and this is connected to the open data. What we would like to share as a message, or to convey as a message, is that maybe 90% of the data that the public sector are able to share with us is under this very positive framework of public sector initiative. I already said that it would be nice that we have someone who has a background in law but with some knowledge of our area. We do have experts that can handle the practical cases if some of the people willing to donate data face a very particular thing. So the slides were designed by the consortium, and in the consortium we have lawyers that have been working with us for almost a decade now, so they are very familiar with the problems that we are dealing with. And the message that we wanted them to convey is that there is a regime under which this data can be flown across the EU, including for the EU services. And I'm just going through this slides very quickly. Does the PSI, Public Sector Initiative Directive, make a difference? Yes, it does. It makes the life of many public bodies more easy because they have this argument if it comes to arguing with their management or their bosses. The existing PSI is very positive. It has a clear picture about how public data should be released. A number of institutions that were excluded at the beginning, like museums and libraries, have been integrated in the latest version of the directive. And this directive has been adapted or adopted in local laws almost everywhere. There's a couple of exceptions where some countries just agreed that it was part of the national law already and didn't want to implement it. So maybe the lawyer or the speaker for that session should elaborate on some very basic concept that the participant should get familiar with. The first one is this Psi Rules. That's for the public data. There is things that have to be under copyright when you buy resources from some authors, some agencies, some whatever. It is copyrighted data. There is some issues about data protection rules that could be for privacy, for confidentiality, for security, for a number of reasons. And there is a number of subjects that we can exclude. So these are the basic concept, and can just take you through the slides very quickly. If someone feels that these have to be adapted or should be localized in a different way, we're very happy to talk about that. I'm not going to go through this in detail right now. PSI is the important thing. This is what the public bodies are supposed to comply with. But if we go to protection rules, as we said this morning, there is some resources where you have collected interviews or things like that, and you have already asked the participant the consent to release this publicly, then you are in the safe side. But you may have data that has some personal information and you need to anonymize that. You can do it. In many cases, you cannot do it with reasonable cost and effort, and then we just forget about it. So the question that we will be asked, and we have been asked, how will my data be used by the consortium? And the clear picture that we tried to make since this morning is that we are going to use the data for machine translation training. So we will take the pieces from the text, align it, and use it to train some mathematical algorithms. We're not going to release the data publicly or publish it or whatever. And what our lawyer suggested is that we try to describe the stages that we can go through if we want to release the data in that framework. The first thing is exclude all the information that is labeled as confidential in your corpora. Try to get the consent of the contributors. If you do have contributors, like I said, interviews or things like that. If you can do that, you have to anonymize. If you cannot anonymize, exclude the data. Very often, even within public sector institutions, you may have data that you license from third party. This is not your property. You cannot release it. So just make sure that this is excluded from the thing. In many countries, there is this transposition of the public sector initiative or public sector directive. In some countries, they have come up with a license for this PSI data. We saw that in France, in UK, and in many countries. And these licenses are quite easy to use. In other countries, they just decide this is public domain. So no need for a license for that. So if you're in a country where these government licenses are available, please make sure that you use them. If you feel that it's more public domain style of data, make sure that you release it. To make sure that the people understand all these differences and things like that, we selected 3-4 examples of the kind of data associated with licenses. We have an example from UK where we list here the reference to the law, and the first one is from Greece, sorry. The Greek decide that all the public data is open by default, and you have examples. We have the reference to the local legislation. We have an example from the UK transposition of the PSI regulation, where you see that they have their own license. Another example from UK. So if you feel that these examples are fair enough, you can use them. If you feel that you would like to have a local example, please please do so. Yeah, this is examples from different countries. We have even a couple of examples from private organizations like ELRA, where you have specific licenses that are still useful because they are resources that the Commission can license, so we can mention them. And this is in many countries, you have either MetaShare, you have Clarin. You can also list this as potential sources of public data if doable. And the most important message is we do have this framework that we can work within all together, but we also have the help desk with legal people that are familiar with the European law with respect to that, and they are also connected to a number of networks. And so if we need to check what's going on in Estonia, our network of lawyers might have some connections to Estonia, and if they don't, they might come to you and say, okay, who is the copyright expert in Estonia? Can we talk to some university professors who might indicate who is the best person to talk to for that particular case to make sure that we can solve it? And if it's very hard to solve, or if we have doubts, then we can just leave the data out. So this is the legal session. It was given by a lawyer in Greece and in Riga, the same person. So he gave it, I think, in English in Riga, in Greek in Athens, and we have a German lawyer who made the presentation here in Germany. So we're now going through all this Creative Commons movement to identify all the experts across Europe. There is a network of legal experts with respect to that, and we hope to find some people all over the countries we are dealing with. Questions?
Yes, thank you. For the copyrighted material, would it also make sense, because we are mainly interested in the language models, would it also make sense to offer the text owners or the text licensees to just give us the language models to do the processing at their side and do not give out the corpora as such, but only the n-gram list or whatever language model we are interested in?
Andrea, this is not part of the mandate we have. We have a clear mandate to collect real resources. And the basic argument is that we know how to do language modeling for machine translation Moses version 1.3. No one can pretend today to be able to say what would be the language models for version 2.5. And that's probably why the Commission wants the real stuff, so they can do the modeling themselves. But apart from the project, of course, the community interest is to have the best technology. So I'm sure that Spiros will be very happy to talk to you about this and see if something can be done. Yeah.
It's not so much a question, but rather a comment. We have engaged an expert from the National Intellectual Property Rights Office. And I had, well, that was our #1 target, but we also heard from Stelios and asked to contact the Creative Commons Hungary person. Unfortunately, he is unavailable because he's now currently based in Holland. So that's why we ended up with this person. And I had a preliminary chat with her about the talk and asked her about her attitude to Creative Commons. Yes, I'll be coming to that. But then she summarily dismissed Creative Commons as simply not applicable to Hungarian law, which requires written bilateral agreement. And this is something that Creative Commons, in her view, cannot deliver. So what to do in such a situation?
That's a very strong statement, because those who are familiar with the Creative Commons movement I remember that up to version 3 dot something, we had in these Creative Commons movements what they called the ported versions, versions that have been adapted to many countries. I should confess that I didn't check if they ported it to the Hungarian law. We should check that. And then they moved to version 4.0, which is the international version. And everyone now assumes that the Creative Commons 4.0 is applicable to most of the European Union countries. So we have to check with some experts. What I said in my presentation is that we have to check case by case, because in some countries like France, like UK, like Greece, but I'm sure it's a general trend, there is what they call the government license. If you look at the French license, it's inspired the same spirit as Creative Commons, except that it's a different text of law, but the same spirit. It makes sure that things are available and available under very permissive conditions. The same for UK and the same for Greece. So maybe there is a different license, and the license in UK, for instance, you don't have to sign it. It's an implicit license. So maybe for Hungary we have to check, and maybe for some other cases, if you feel that your expert is not coming with solutions, because that's why we would like to have experts in this session, is to bring solutions for the purposes we are trying to achieve. So if someone says, no, it's impossible for Hungary to do anything of this, that's not really a positive statement.